Brilliant. Hello and good morning and welcome to this morning's webinar. I am GDPR for employers. What does it mean for your business? My name is Laura Murphy and this morning I'm joined by my colleague Jennifer Huzzy. Good morning. So I suppose with the countdown to the introduction of GDPR on the 25th of May really is well and truly on now. And we just want to provide a recap of the key elements of GDPR and look at some of the areas that we feel that businesses should be looking at if you haven't already started preparing. Just before we get going, to say we are recording the webinar and a copy of the recording plus the slides will be sent to you later on today. As always, we've a half an hour scheduled for Q&A at the end, so please do type your questions in as you think of them. And I think then I'm just looking over to check that the sound is all okay. So we'll get going because we do have a busy schedule. So first and foremost, what is GDPR? GDPR stands for the General Data Protection Regulation. It's a new European-wide privacy regulation, and it replaces all existing data protection regulation right across all EU member states. It is an extremely significant piece of legislation and it does change how personal data is managed. I suppose the ultimate objective of the GDPR is to provide better protection for personal data. And I suppose previously personal data was seen as an asset. If you had long marketing email lists, this was great, lots of customer information. However, in the new GDPR era, that's certainly going to be seen as more of a liability than an asset. I suppose if we think about it, excuse me, the current data protection legislation dates back to 1998. So this predates how we use the internet today. It predates all sorts of cloud technology and social media. So absolutely, certainly, modernisation of the legislation was required. That's not to say that the new legislation doesn't give a bit of a headache to employers, and particularly small employers who are trying to get their head around it. But it is, generally, it's a welcome concept.
Absolutely. So on top of the change to the legislation, there are other reasons that you're going to need to pay attention. So first one there is fines. Organisations can be fined with up to 4% of annual global turnover for breaching GDPR or 20 million euro, whichever is the higher. Now, it is important to note that these rules apply to both controllers and processors. So you as a business could also be liable for these fines.
Another reason, I suppose, to pay attention again is that individuals can now take data controllers and processors to court to claim compensation for material loss and non-material loss. So this could be compensation for distress, hurt feelings, reputational damage, even if there is no financial loss or proven financial loss. So if you have a GDPR breach or a breach of personal data on top of the fines that Jenny has just talked about, you could see yourself faced with a civil case with additional fines as well.
Exactly, and obviously there's other factors then that you need to take into consideration. You've got brand damage, and it has been reported that the breaches will be publicised, so that's going to be a very real factor for SMEs certainly. You've got loss of business, the cost of investigation, on top of those civil claims that Laura's spoken of there, you've got the cost of the investigation, litigation, remediation as well.
And time spent on all of them as well. Now, we don't want to overly scare you, and certainly this webinar is not about scaring you, but we wouldn't be giving you a full webinar if we weren't to touch on these fines. And it is believed that the fines will be proportionate and may not even be issued in every case of infringement. And certainly from what we've heard about the ICO, who we'll talk about next, they're not setting out to be punitive in nature. So if you are able to demonstrate that you have taken steps to demonstrate compliance, then then mitigating circumstances will be taken into account. However, if you've buried your head in the sand around GDPR, then you're going to be looking at the larger end of the scale in terms of fines should you have a data breach. So I just mentioned there the ICO. As most of you know, the supervising authority in the UK is the Information Commissioner's Office. And there also will be a European-wide European Data Protection Board, which among other things will adjudicate on disputes if they escalate. I have to say the ICO has excellent resources in place, particularly for small businesses. And actually, well, last year now in November, they launched a helpline specifically for small companies in preparation for the GDPR, and we've used it ourselves here on a number of occasions where we're just looking for clarity on different issues. And I have to say it's an excellent resource. There is a bit of a queue getting through at the moment, but that's to be expected. And then just finally, because we've got this question a couple of times when we do these webinars, the requirement to register. So there is a requirement under the Digital Economy Act in the UK, which means it's a legal requirement for data controllers to register with the ICO and pay a small fee. I think that fee for most small employers is about £35. And there's no requirement to register with the GDPR, but the requirement still exists under the Digital Economy Act. So if you've been registering up till now, you'll just need to continue doing so.
Okay, so we'll look at who the GDPR is going to apply to. And the most commonly held misconception that we've come across about the GDPR is that it doesn't apply to small and medium-sized businesses, specifically the SMEs with less than 250 employees. This is absolutely not the case. The GDPR does apply to all businesses, regardless of their size. So that's going to include the likes of sole traders, clubs and societies, charities, registered charities, non-profit organizations. So if your business holds or processes personal data, then the GDPR is going to apply to you. It applies to the electronic or the automated processing of personal data. So, if you have information on your PCs, emails, things like that, but also to manual paper-based processing. So if your personal data forms part of a filing system or even a notebook on your desk, that's still going to fall under the GDPR. Now, it doesn't just apply to businesses within the EU, it also applies to businesses outside the EU that trade with individuals within the EU as well. So it is across the board.
Absolutely. Anybody who does business in the EU, the GDPR is going to apply for. And even over the weekend, I've seen such an increase in the emails that I've got of the people that I've subscribed to. And you will see things from Google and Facebook and different apps. It'll all apply to those US companies as well.
Yeah.
Just very briefly before we go off this slide, just to touch on Brexit. The GDPR, obviously, we've said comes into force in this May, on the 25th of this month, and obviously the UK won't have departed the EU at that stage. So the GDPR very much applies in the UK from the 25th of May, and certainly, I think the ICO have been a leader in the new concepts.
Yeah.
So certainly the UK will continue, all signs are that you'll continue with a similar piece of legislation post-Brexit.
Absolutely, because I think the Queen even mentioned it in her speech.
She did last summer. Yeah, so it's coming from the top. Very briefly, we've mentioned some terms already, so I just want to clarify them before we go on any further and confuse you anymore, just to give you some meaning behind them. So a data subject, that's an individual who is the subject of personal data. So in a small employment situation, it's going to be your employees, it's their data, or your customers' data. Data controller, the data controller controls the content and the use of personal data. That's going to be you. You're a data controller of your data subjects' data, your employees or your customers' data. A processor is a person, public authority, agency, or any other body which processes personal data on behalf of a controller. So if you outsource your payroll, for example, your payroll bureau will be your data processor. Processing, this means any operation which is performed on personal data, whether or not by automated means, and it's really, really open. So it could be anything from the collection, the recording, the storing, alteration, and use. So it's really quite wide and varied as to who a processor would be. And then a personal data breach, it means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of or access to personal data transmitted, stored or otherwise processed. So hopefully you won't have a personal data breach, but that's what it is. Okay, so I want to look at what are the changes. Obviously we've data protection legislation in place at the moment. What are the key changes? We've gone through the legislation and we've identified what we feel to be 10 key changes with the new GDPR legislation. So we want to go through each one of these points in a bit more detail now. So the first one is personal data, and I'm sure at this stage you're wondering, well, what is personal data? What would be considered as personal data? The definition of personal data is any information related to a natural person or data subject that can be used to directly or indirectly identify the person. So I've given a list here, of anything that it could be, and this is by no means an exhaustive list. So it could be anything from a name, a photo, A new one to this list actually is the last one, the IP address. That would be considered personal data because you could from that figure out who they are and where they are. Yeah. So I suppose the question for a small employer is, or small business, do you hold any of this type of information in your company about any of your customers or your employees? Well, of course you do. You couldn't really do business without it. So the GDPR will apply to you and you need to be aware of its particulars.
Absolutely. Then we'll look at the special categories of data. So the definition of special categories or sensitive personal data is extended by the GDPR regulation. So it's adding genetic and biometric data to this protected category of information. So under the expanded definition, the categories are listed there. So the likes of racial or ethnic origin, trade union membership, kind of processing of large data. So basically what it ends up being is that there's going to be more onerous conditions in order to legitimize the processing of this data. In particular, you're going to need the explicit consent of individuals if you plan on processing any of that. We'll look at that a little bit later on. One of the interesting ones that we have come up with a number of times on the support lines is the processing of genetic data or biometric data for the purpose of uniquely identifying an individual, whereby employees use a clock-in system, use their fingerprint or their handprint in a clock-in system. This is going to be considered as biometric data, and realistically, unless the employer can make legitimate argument that the processing of this biometric data is for the vital interests of the employees or is in the public interest, then it's going to be kind of difficult to continue to be able to record the information in this regard.
Yeah. Maybe it should be optional, I think.
Yeah, or certainly give them another option.
Another alternative, yeah.
So under the current data protection legislation, we have 8 principles of data protection. And this has been reduced to 6, but if anything, it's been bulked up. None of the content has been lost. So under the new GDPR regulations, personal data should be processed lawfully, fairly, and in a transparent manner. It should be collected for specific, explicit and legitimate purposes and not further processed in a manner that is incompatible with those purposes. It has to be adequate and relevant and limited to what is necessary in relation to the purposes for which it was collected. It needs to be accurate and where necessary kept up to date. You have to ensure that every reasonable step is taken so that personal data that is inaccurate or incorrect is erased or rectified without delay. It needs to be kept in a form which permits identification of data subjects for no longer than a required period of time or no longer than what is necessary. And it has to be processed in a manner that ensures appropriate security of that personal data. So this includes protection against unauthorized or unlawful processing, accidental loss, destruction, damage, etc. And using appropriate technical or organizational measures. And we'll hear that a good few times as we go through the webinar this morning. But really what we're looking at here is the overarching principle is accountability. You're going to need to be able to demonstrate compliance with these principles and, therefore there's a burden of proof, on you as the controller or on you as the processor to ensure this compliance.
Yeah, this is a new term, I suppose, when we talk about data protection. Accountability is a new concept of the GDPR, but it's very much the overriding principle is that now data protection always applied to companies. Now you have to be able to prove that you're compliant and you have to show accountability.
Exactly. So if we look at the reasons now as to why you can process data. So the processing of personal data is only lawful if one or more of the following criteria is met. So the data subject has given you consent. And again, we'll come back to this shortly. If it's necessary for the performance of a contract or to take steps prior to entering into a contract. So if you're providing your service, if you're retaining a hotel booking, information like that is deemed as a contract. It's only lawful if it's necessary for the compliance with the legal obligation to which the controller is subject. So again, if we look at the payroll, you as the controller, the company, you're obliged to, deduct taxes from your employees and things like that. So there's your legal obligation covered. It's only lawful if it's in order to protect the vital interests of a person. It's only lawful if it's necessary for the public interest or official authority. So that's going to refer to, your public sector bodies like the police, social aspects, things like that, county courts. And then finally, for the legitimate interests of a data controller or yourself, the employer. And this is really where you can have a little bit more flexibility in classifying your processing, as to why you need to do that. So when you're reviewing the data, that you process and you're asking yourself, is it lawful for us to process it? These are the points you need to look at. And if you're unable to tick off any of them, then really you need to stop processing the data that you currently have.
Absolutely. And I think just the first point you made there is that you just need one or more. You don't have to tick off all of these in every situation. So certainly in terms of processing your employee data, I'd be relying on the necessary performance of a contract and legal obligation in terms of employment law, and possibly legitimate interests as well. So you've got plenty there in terms of ticking off your employee data. The one I want to talk about in more detail, because I think there's a lot of changes here, is the first one is if you're relying on consent to process data. If you are relying on consent, you need to be aware now that there is an elevated threshold for consent. And in terms of your business, you may need to rely on consent. I think the one that we come across most is for marketing material, your marketing email lists, whether it's newsletters you're sending out. So if you have somebody on an emailing list, you need to ensure that they have actively opted in and have given consent to be on that list. So there's 4 key concepts with the changes in relation to consent. And the first one is a consent. It must be specific, informed, unambiguous and freely given, and it must be for a specified purpose, so no one size fits all. So again, and the unambiguous, it must be really clear as well. Where consent then is obtained as part of a larger document covering other things such as other business T's and C's, consent text must be clearly distinguished from everything else. So if you were, at the end of the sales process, you ask a customer to tick a box here to agree to T's and C's, and as part of the T's and C's is that they're now going to be included on all mailing lists for your group company, that would be incorrect. Consent must be almost a separate tick box, really. You need to retain evidence as to how the consent was obtained. So, for example, forms, brochures, screenshots, wherever you can get evidence. And again, it must be evidence that affirmative action has been given. And I said earlier, I've seen loads of emails coming into the inboxes, my personal, my work one, and some of them say if you wish to be taken off,
or opt out,
tick here, which is incorrect. It's if you wish to opt in, so you actually assume that assume it's an opt out.
Exactly. First. Yeah, it has to be that affirmative action that you're freely given the consent for it.
And then the fourth one is the language must be accessible and easily understood. This is a key theme throughout the GDPR regulations, and it's very much the thought process is that all kind of legalese, data protection language should be removed when you're dealing with your customers, particularly if their customers are under the age of 16. You really have to present your policies and your documentation in a format that's really understood, I suppose. So I suppose just on this point then as well, so just because somebody is a customer, this doesn't mean that you can automatically add them to your mailing list and tell them about every special offer that you have. And certainly, again, from my own personal experience, you might have stayed at a hotel 2 years ago and you're still getting emails about their Easter offers or whatever it is. You can't assume that unless they have actively opted in.
Absolutely, and that brings up quite an interesting question in relation to the purchasing of mailing lists. Our understanding under the GDPR is that the purchasing of mailing lists is something that is going to be defunct post 25th of May. So we really wouldn't be recommending purchasing any form of mailing lists after that point.
And just to say, on email addresses are personal data. So my email address, laura@brightpay.co.uk, is my personal data. However, if on my mailing list I had an email address that was admin@brightpay.co.uk or sales@brightpay.co.uk, so that's a generic email address, and that is certainly fine to keep on your list. But if it's a name and a company, then they'll be removing it unless you've got the consent. Okay, so we move on.
Okay, so we look at the data controller and the data processor. So the current legislation places most of the responsibility to comply with the data protection laws with the data controller, i.e. if you're a company sub-processing your payroll out, you have most of the responsibility. However, under the new GDPR, data processors have more direct compliance responsibilities. The data controllers may only appoint data processors which provide sufficient guarantees to implement appropriate technical and organisational measures to ensure that processing meets the requirements of the GDPR. So if you are a small business and you outsource your payroll, for example, you need to be checking that your payroll bureau is taking those steps towards GDPR compliance. Equally, if you're processing the data on behalf of somebody else, perhaps you are the payroll bureau, then we would be recommending that you're notifying your clients that you are GDPR compliant, or certainly, in the remit to that. And we would say use the GDPR as an opportunity to kind of advertise your knowledge on the area and win clients as opposed to lose them.
Yeah.
A second point there in relation to the data processors, that they're only permitted to process personal data in accordance with the controller's written instructions. That's quite a new one. So the relationship between the controller and a processor must be governed by a written contract, and the GDPR specifically sets out what must actually be in this contract.
And I think we're going to go into that in a little bit more detail later on, but I do know from our registration list that we have a number of payroll bureaus and accountants online today, and certainly you'd be data processors, and I guess Jenny said our advice to you would be to get ahead of this if you haven't already, and get your data process agreements in place with your clients. But we'll come back to that in more detail, because I know we want to talk about security, which is a big issue with GDPR, and given the potential and significant impact of security breaches, data security is addressed significantly within the GDPR, and it contains both preventative and reactive requirements in respect of personal data. So the regulations state that organisations should have, and I think Jenny has already referred to this, technical and organisational preventative measures in place. So that's a really important term when we talk about GDPR, is the technical and organisational measures that will help A, prevent a breach from happening, and B, that will minimise the impact should a breach actually occur. So the technical measures would be encryption, pseudonymization, a process, and then also to have maybe a process for regularly testing any encryption that you have in place, and assessing whether or not it's effective. Then in terms of your organisational measures, I think these are wide and vary hugely, and will depend on your organisation and what you do and what kind of data you hold. But I suppose to give a couple of examples of what might be an organisational measure, and they can be quite simple, they don't have to be highly technical. It could be something as simple, as using an unsupported version of Windows, and we come across it quite a lot on our support lines where we have customers who are perhaps using Windows XP, and I'd certainly say if you want to look like you're GDPR prepared, don't be using Windows XP. This is an unsupported software, and it's highly open to risks and whatnot. Malware, exactly.
Yeah. Another one then is the likes of open Wi-Fi. So if you offer, open Wi-Fi in your premises, to ensure the security of this, I think you have a case.
Yeah, well, we had a conference that we were at, and it was a security company, and they did security audits. So they went in to do an audit on a store, and they were able to get into the Wi-Fi, the open Wi-Fi of the store, and from there they were able to hack into the tills of the store and gain all sorts of access in relation to the sales and the till information. Obviously that was done in a secure audit environment, but it just goes to show if you have an open Wi-Fi, the risks that are involved there as well.
Yeah, that's something I wasn't, unsure of myself, so I won't be logging into my banking online when I go to the department store again.
Scary.
Exactly.
Other ones, again, is really simple, a clean desk policy, and again we've come across it where people say it was a car garage. We had an example of it, who were taking customers' information in a booklet and leaving the notebook on the front desk of the garage where all sorts of customers were coming in, and they were saying, well, we close it, so is that secure? No, not really. You would certainly, if your receptionist wasn't there, you'd be locking that away or putting it in the bottom drawer kind of thing. Exactly. So it's, and if you're an accountancy, what kind of customer files are on your staff desk, who would be able to go and have a look at them, staff that might not necessarily need access to that customer file. So
Exactly.
simple things that will, again, simple things and measures, but should the ICO come down and you are doing inspection, they're great to have.
Absolutely. Another one there that we came across was the likes of a payroll bureau. So they had one of their employees who was actually working from home at certain times and working on clients' payroll, obviously. And the company didn't have any issue with this until she left. And then it was kind of a bit of what do we do now? How do we know, has she deleted this information? What records does she still have on file? So, putting in place a policy there, like a working from home policy, implementing something like that to ensure that, information, confidential information is removed from an individual's device if they're leaving. It might seem like a simple thing, but, until you've come across it, it mightn't be.
Yeah, and just to move on then to the breaches, so looking at the reactive measures then when a breach does occur. So the GDPR introduces a duty on organisations to report breaches to the relevant supervising authority, so the ICO in our case, and in some cases to the individuals who were affected by the breach. So we've already kind of looked at what a breach is, and what a breach is in your company will differ, and I think certainly the worst breach that we're kind of thinking about is identity theft, but certainly if we have accountants and people who are doing payroll and holding employee data, well, identity theft is a risk there. But in terms of reporting a breach, you don't have to report all breaches. Where a breach is likely to result in a risk to the rights and the freedoms of individuals, it will need to be reported to the ICO. So for example, if it's resulting in discrimination, damage to reputation, financial loss, then it'll need to be reported to the ICO, and you'll have to assess that on a case-by-case basis internally and make a decision. In terms of when you need to report a breach to the individuals who are affected, the go-to guide is that breaches that are likely to result in a high risk to the rights and freedoms of an individual. So that difference there is the high risk, meaning that the threshold for notifying the individuals is higher than notifying the ICO. If it is the case that you need to report a breach, you must do so within 72 hours of becoming aware of the breach. And that's not 72 working hours. So if you become aware of a breach on a Friday afternoon, the clock starts ticking straight away. So I suppose in terms of preparing for this, what I'd be saying to you is that you need to firstly, ensure that your staff understand what constitutes a breach in your company, so that they know when alarm bells should ring and when they should notify their manager or whoever it is. And then you should also have maybe appointed somebody internally that is going to make that final call as to, right, well, now this is the breach, do we need to report that to the ICO? If you decide no, it's not a high risk or there's no risk here, but certainly was a breach, you still need to record the breach and make a record of why you didn't report it, and equally then what steps you took in place to minimise the effect of it and prevent it happening again.
Just a point on that, actually, if you are using the likes of a third-party data processor such as a payroll bureau, it will be a requirement for them to notify you immediately if a breach occurs. So it's going to be important to ensure that you have up-to-date contracts in place or arrangements with any third party that you are outsourced personal data to.
Yeah, we talk about a DPA later on, but in your agreement, your kind of data protection agreement with your processor, that would be a key point to include in it, that you're notified of breaches.
Absolutely. So just to look at now the Data Protection Officer, the DPO. So this is a new role that will come into effect with the GDPR. And the main role of the DPO is going to be to monitor internal compliance with the regulations. Now, realistically, you're only going to need a DPO if you're, kind of an organisation engaged in large-scale systematic monitoring, if you're a public body, or, working with kind of processing with special or large categories of data. But just to look into it a little bit, the DPO must have expert knowledge of the data protection law. And for many companies, it's unlikely that they're going to have a skill set like that amongst the current staff. So you may look at recruiting or even outsourcing it. The DPO must be involved in a timely manner in discussions of the personal data processing, so they're aware and they're involved at all stages of it. They mustn't have an internal conflict of interest, so realistically it couldn't be the HR manager.
Or your finance manager.
Exactly, because the conflict is there. They have to be sufficiently senior to be able to implement obligations, because they're going to be reporting to the highest level of management, so they need to be able to stand up to, the director or the CEO, whatever it might be. As we said, it doesn't have to be an employee, so outsourcing is more than likely going to be quite common. And if you have a group of, kind of companies maybe scattered throughout the county or the country, you can have just one DPO that will oversee all of the groups within the one organisation.
Just on the DPO, it's not for us to make any sort of sweeping statements at all, but certainly I would question whether many SMEs need a DPO. Now, obviously, that will depend on the type of data processing you do, but I would imagine it's unlikely. But certainly, would still, when you're building your GDPR folder of compliance and having a folder there of all the steps you've taken to show compliance, I'd be putting consideration in place, I suppose.
Absolutely. As Laura touched on there, with the breaching of, there'd be no harm in appointing somebody or having somebody as being that kind of go-to
Yeah,
person.
You'll still have a go-to person, certainly, absolutely. So we move on then to the 9th of our 10 points, and it's the enhanced rights for your data subjects. So individuals do have new and enhanced rights under the GDPR. So again, if you're an employer, these enhanced rights will be for your individuals, but equally for your customers and their data as well. So the first right that is the right to be informed, and this emphasises the need for transparency, and that's a key, again, another key theme of the GDPR is being transparent in how you use personal data. So you must be very clear with your data subjects about how you use their data, what data you hold, how long you're holding it for. So we'll talk about privacy policies later on, but you need to be reviewing your privacy policies.
Sorry, the next one then is the right of access. So this is where your data subject requests access to the data you hold on them. So there's a number of key points to that. So the time frame for response has been reduced from 40 days, which it is at the moment, to 1 month. And you'll need to keep in mind that if the request is made electronically, i.e. via email, then you should provide the information in that same format. Currently, you can charge £10, I think,
yeah.
If data subject requests access. Under the GDPR, there will be no charge, so that'll be gone. And you can refuse a request if it is manifestly unfounded or excessive. So, where it might be permissible to refuse a data subject request would be if you receive an access request within a short time of already having responded to a request. Well, then you can turn around and just say, listen, we've already provided a lot of this information. We're not going to do it again.
And equally on that, you're saying that the time frame has been reduced from 40 days to 1 month. Again, if it is an excessive request where there's a lot of information or it might not necessarily be to hand, you can again write to the individual and extend that time frame as well. So there are options there as well. The next one is the right to rectification. This is an existing right, so individuals are entitled to have the personal data rectified if it is inaccurate or incomplete. And then the next one, the right to erasure, also known as the right to be forgotten. The broad principle being here that an individual has the right to request the deletion or removal of personal data. And then the important part here is where there is no compelling reason to retain the data. So in an employment situation, I suppose you have to, in order to be compliant with employment law, you have to retain certain employee data. So if an employee came and requested that that data be removed, you don't necessarily have to remove it.
Absolutely. The next one then is the right to restrict the processing of personal data. So this is where an individual, a data subject, may have a particular reason for wanting that restriction, and that could be because maybe they have issues of the content of the information that you hold or how it's been processed. The next one then is the right to data portability. So this allows individuals to move, copy or transfer personal data from one IT environment to another once it's done in a safe and secure way. This is commonly done in the banking industries.
Yeah, it's a big issue for banks trying to prepare for this one at the moment. Then the final two is the right to object to the processing of personal data. The obvious example here is the direct marketing purposes. So if somebody has given you consent and has decided to opt into your mailing list, they can object at any time. So when you are sending out a mail shot or a newsletter or whatever it is, you must again include that unsubscribe button and make that available to them. That's just one example, I suppose. And then the last one is the rights in relation to automated decision making, and this is a new right. So where automated decision making exists or relates to any form of processing to evaluate personal characteristics, I suppose, and it can be, you know, with the introduction of AI, we're seeing it coming in more and more. So we're seeing it a lot in recruitment at the moment. You'd see it in health, work performance, finance, big thing. If people were going for a loan, it might just be used on automated criteria. So where this is in existence, or where it's in place, the individual has a right to interject in that decision-making process, and they can obtain human intervention, they can express their own point of view, and they can request to get an explanation on why a decision was made. So that's the rights. So I just want to kind of delve off that a little bit and talk about data from a GDPR from a HR perspective. Data in the employment context will include information obtained from an employee during the recruitment process, even whether or not they eventually get the job. And of course will include information that you hold on your current employees and your previous employees. And as Jenny referred to earlier, you may have that information saved in hard copies on personal files. It can be held on HR systems, on your payroll systems. It could be held across a range of different formats, I suppose. And when we look back at the lawful processing of data, when Jenny had the list and we said you needed to tick off one or more, and consent was the first one, and up until now one of the most commonly relied grounds on for the lawful processing of HR personal data was consent. So historically there was a generic clause in the contract of employment that said we will process your data protection clause, we will process your data, you know, something like that. That's not going to be sufficient any longer. As we said earlier when we were talking about consent, under GDPR, consent must be freely given, specific, informed and unambiguous. And what the experts are saying in relation to GDPR is that given the imbalance of power between employees and employers, employers effectively holding more of the power. I know some employers argue as well with the employees, but effectively in terms of offering a job and accepting it, the power is with the employers. It'll be difficult in this situation for consent to be freely given, which means that you can't rely on consent from a HR point of view. So you're going to have to rely on one of the other reasons that Jenny talked about on that list. So as I pointed out earlier, that'll probably be the legitimate interest of the business and the performance of a contract or a legal obligation to hold leave records, Organisational Working Time Act, that kind of thing that you'll be relying on, yeah. So the next thing to be mindful then of in terms of your employers is the increased rights that we've just talked about and the right to information. So employers really do need to provide more detailed information. That one small clause in the contract isn't sufficient anymore around data protection. You're going to need to provide a much more detailed policy on what information you hold of employees, what you do with it, who you share it with. Do you use a payroll bureau? You have to provide that information to your employees. You don't need to get consent, you don't need to get their approval, but you have to tell them that we hold your payroll information and we share it with ABC accountants and they do our payroll. So you'll need to be looking at your data protection policies or your employee privacy policies.
Absolutely.
So I suppose then just to summarise quickly on the HR side of things, be clear on the reasons why you're retaining and processing your employee data, amend your data protection policies or think about implementing employee privacy policies, and consider that if you're consider to be providing data in a transparent manner. And there's a new recommendation within the GDPR that it's a recommendation, it's not law, but it requests that employers should consider where possible to introduce or to provide remote access to a secure self-service system, where employees can log in and see their information. And if you want to be kind of looking at that transparency issue and being one step ahead, I think then certainly a self-service option would be a good consideration, but we'll talk more about that a little later on.
Just one thing comes to mind there, just when you're talking about the legitimate, kind of interest, and something that's come up a few times is how long you keep that employee data for. There's a certain amount of employment legislation that obviously stipulates how long your data should be retained for. So as Laura's touched on there, your annual leave records, maternity leave, tax records, etc. In other areas such as recruitment and performance management, employers will have more flexibility to decide on how long they're going to hold on to that data for. And again, referring back to the privacy policy or the employee privacy policy, once you decide in your retention periods, they need to be clearly set out in that privacy policy too.
Okay, so we just move on to the last point that was on our list.
Yeah, so we've got kind of three new concepts here. We've got privacy by design and privacy by default, and these are quite important new concepts under the GDPR. So the privacy by design requires organizations to consider the privacy measures during the product design processes, so right from the very beginning, whereas the privacy by default requires controllers to ensure that only necessary data is processed. Really what they're looking at there is that your privacy is embedded into the DNA of the organization, and it's not just a second thought, that comes around after a breach has occurred, but that you are seen to take it into consideration. The GDPR also requires formal data protection impact assessments, or PIAs, in relation to higher risk processing. So as a data controller, if you carry out, a new processing activity, and maybe that processing will result in a high risk to the individual, you're going to be required to conduct a protection impact assessment. The likes of high risk processing might include, something similar to the special categories, processing in a large or systematic monitoring of special categories or sensitive data, or like that, the large scale systematic monitoring of the likes of a public area. So the regulations are providing guidance on, exactly what needs to be included in that, which is, a lot more detailed as well, but just to touch on it there for you.
Perfect. Okay, so we've done our 10 key differences. Hopefully you have a bit of a greater understanding now of what's entailed in the GDPR. And before we finish up and go to questions, we wanted to look at how you can start preparing, well, if you haven't already started preparing. We've kind of highlighted 7 steps that we feel businesses should consider when starting to prepare for GDPR. We want to look into these in a bit more detail. But just to go through them briefly, which the first step of your preparation is to complete an inventory of all the data that you hold and process. And this is a big step in helping your company become accountable, which we've seen is one of the key concepts of the GDPR. Then I suppose the steps you follow next might not come in this order, and it'll probably depend on the outcome of your inventory, but we'll go through them in this order. This can be flexible, I suppose. You want to look at your employee preparation, getting your employee data in order. You want to review your existing privacy policies with customers and any third parties that you use. Capturing consent. If you are relying on consent as a legitimate reason for processing data, you need to be taking action straight away, because come the 25th of May, you can't use that data where you don't have consent. Governance. Yeah, I haven't skipped one. Governance. No. GDPR is an ongoing issue. It's not a tick box exercise that we do once. So you want to plan how you're going to maintain compliance. Security, you're going to look at your security measures, the technical and organizational measures that we talked about. That's going to be a big part of your process. And then, as Jenny just mentioned, your data by design and data by default. You'll look at wanting to take steps to embed data privacy into your organization.
Exactly. So the first step we're looking at is to review all the personal data you hold. So whether that data relates to current or former customers, current or past employees, unsuccessful job applicants, or other third parties. the ICO has suggested that, examining all kind of such personal data under these headings. So why are you holding that data? What is the legal basis for it? How did you obtain it? Why was it originally gathered? How long is it held for? Is it secure? Do you share it with anybody? Is it shared outside the EU? Do you process any special categories of data or children's data? The GDPR requires organisations to be in a position to demonstrate compliance with the new requirements, and documenting that in the inventory is really going to enable employers to, one, identify any gaps that they have in the compliance, and then be able to put in place, kind of processes or policies to rectify those gaps. And again, another thing, the accountability aspect of it, you then have evidence of, kind of complying to the new regulations under the GDPR.
Yeah, and the action that you've taken or you've made a start. So it's a really important step in terms of your accountability.
Exactly.
It doesn't have to be an overcomplicated process. Internally here we just use an Excel document and we broke it up into 3 worksheets: our marketing information, our customer data, our employee data, and that really helped us then kind of plan as to how we were going to go forward in each area. The one thing I would say, having gone through it ourselves, is to get to talking to as many people in your company as possible. It's not something that one person can do. Everybody is going to think of something else or some other piece of data that you hold that you never thought of. But certainly if you haven't done a data inventory, do it today, do it tomorrow. That's your first step.
Absolutely.
Okay, so your employee preparation. We spoke earlier about the need to determine what your lawful reasoning for maintaining your employee data will be. So once you determine this, you'll need to communicate it clearly to your employees. So I think I've already stressed the importance of your employee privacy policies or your data protection policies. In terms of the employee privacy policy, if you're a Bright Contract software user, we have an update to our software coming next week, which will include a full employee privacy policy, which includes all that information that you need to provide your employees. So that's coming next week. Go back to what we said earlier, other policies that you might consider looking at will be a clean desk policy, perhaps a working from home policy.
Shredding policy.
Yeah, that's a big one.
They don't like it too much, but even just putting a rota in place is who's going to do the shredding once a week.
We had an example that we heard of where somebody had a shredding bin and all the paper was put in that bin, and then every week somebody came and took that shredding away, but it wasn't actually shredded. He used it for his dogs on their beds. So that's a bit of a risk. So you need to be sure that if you have a shredding bin that it's actually going to go and get shredded.
Bit of nighttime reading for the puppies.
Yeah. And then the second key consideration in relation to your employee preparation is the one that we spoke about earlier, is this concept of the employee self-service option. So again, I think that it really will be prudent for employers to at least consider the possibility of having an employee self-service where they can log in and see their information. And as we said earlier, the core of GDPR is transparency and data subjects having access to the data being held on them. So a cloud offering would certainly provide both of that. So very briefly before we go on to our third preparation step, sorry, that's just a quick look at the Bright Contract software. You'll be familiar as a user with the tabs across the top. We'll have a new tab here with privacy policy, and it'll allow you to create a privacy policy that's unique to your company, but yet we've ensured that all the necessary information is in it as well. And then I also just want to show you our Connect solution. So the BrightPay Connect solution is an add-on solution to our payroll software. So you'll still do your payroll on BrightPay, but the Connect is an add-on to that. But it offers great benefits in terms of becoming GDPR compliant. And we haven't designed it like that. We've had it out since before, I suppose, the dawn of GDPR, but it's worked out that it holds many benefits. So just really to show you briefly, when an employee logs on, and they can log on to with Connect, an employee can, so your employee or your client's employees can log on to the self-service portal on their phone. So even if you're not in an office environment, employees can have access on their phone. So when they log in, they can see all their basic information here, and you'll see here that they can see their name and address, and they can update their details, which again is a fantastic option in terms of, we spoke about the right to rectification. So that's you know, a benefit there. You're pushing that back on the employees. Maybe not so much into GDPR, but they can request their annual leave here as well, which speeds up that whole process. And a touch of a button, you can approve annual leave. The key feature that we're seeing that people are really loving in relation to Connect and GDPR is the ability to make pay slips available on Connect. Now, I just want to stress that emailing pay slips is perfectly acceptable under GDPR. We get that question a lot. You know, once you've taken security measures, and there are strong security measures in place with BrightPay, it's perfectly acceptable to email pay slips under GDPR. However, some of our customers like this feature because once you finalise a pay slip on BrightPay, it's automatically available in Connect. So it takes away that element of risk that maybe email does pose.
Or posting.
Yeah, or posting. We were surprised at how many customers still post pay slips. So it removes that need, and it's a secure way where all your pay information, we've got enrollment letters there as well, can be available online as well. And not only pay information, then our Connect offering, this is where you can really use it as an employee file. You can upload any kind of document, PDF or document, whether it's a contract of employment, a company handbook, a probation period letter, and employees. Obviously, I'm logged in as an employer here at this screen, so I have a number of employees' contracts, but certainly the individual would only be allowed to see their permissions. And I suppose this is an interesting one because when we spoke about the rights to data subjects earlier on, we said the right to subject data access requests. Have we? Yeah. We touched on that, where employees and individuals can request to see a copy of the data that you hold on them. This has always been a right. But in my experience, I've seen it used very, very rarely. However, in the last couple of weeks or months, I've seen at least a number of cases on it, and I think everybody and all employees are that much more aware of their rights, and data protection is hot on the agenda. So I've seen it that employees are now coming to employers and saying, well, I'd like to see the data you hold on me. And certainly an easier way to be able to say, yes, that's no problem, is to have this information all on the Connect, and it can certainly save you as an employer time in that regard.
And headaches.
Of trying to get all the information. And as Jenny said earlier, to provide it electronically as well, which would be a requirement. So it's already there electronically for you. So we move on, to the third step.
Yeah, so we're looking at your customers then. So the first thing you need to be looking at in relation to your customers is your customer privacy policy. So you need to review your data protection notices and analyse whether they require any updating to ensure compliance with the new regulations. However, if you currently don't have data protection or privacy policies in place, you really need to start doing that now. When you're collecting the personal data, the GDPR requires businesses to provide detailed information to the individuals. And that data could be from your customers when they sign up, or, book in with you, or whatever it is. What information you need to provide is more detailed now under the GDPR. So we've created a checklist of that information and what you need to include in your privacy notice. And we'll include this in a link with the email that's sent out at the end of the webinar. But just to touch on a couple of the points that are included in the checklist. The first being the transferring of data outside of the EU. If you do or you intend to transfer an individual's personal data outside the EU, you need to ensure that approved transfer mechanisms are in place to do that. And again, there's further guidance on that international transfer information on the ICO website. And as Laura's touched on already, it really is a brilliant, brilliant website. The second point I want to touch on then is the data retention period. The GDPR does not specify any particular retention periods for personal data. It does, however, state that personal data may only be kept for no longer than is necessary for the purposes for which it was processed or collected. So when you're considering retention periods, businesses should be guided by the statutory retention periods. An individual business needs and the data protection principles in general, but the overlying one there is going to be your statutory obligations, really.
Yeah, they'll always override.
Exactly. The third one then is to identify your third-party contractors. So as we've already seen under the GDPR, whenever a controller so your business, uses a processor, it needs to have a written contract in place. So if you as a business are transferring personal data to another company for them to process that data, you will need to have a contract in place in order to do that. So for example, if you have a pension scheme in place, you're going to be sending on employee data to the pension provider or broker. If you're using a payroll or a HR bureau service, or perhaps you outsource part of your business which involves you sending customer data to a third party, that's all going to need contracts to be put in place. Again, we've created a checklist of what must be included in that contract between the controller and the processor. And again, that's going to be included in the follow-up email. And we have actually got a DPA, that many abbreviations, a data processor agreement drawn up, and that could be used for the likes of a payroll bureau offering, and that's really useful as well. We have a template of that.
Yeah, that's on our website, but we might include it in the email as well, because it's written, we've written it from the point of view of a data processor, so it's for them to put in place with their data controllers. But certainly if I was a data controller, if I'm an employer here now, and I have an obligation to ensure that any processor I'm using is compliant. So as Jenny said, that pension or your payroll bureau, the first thing I'd be doing is I'd be contacting them and saying, I'm doing my GDPR prep, can you please confirm your compliance with GDPR, and can you provide a data processor agreement? So I'd be asking the processor, can they have a data do they have a data processor agreement, and to get that in place. And then if they don't, if they don't come back, you might use our template to say, well, this is a suggested one. Could we agree on this? And if they still don't, then I'd question whether I would want to use them. Continue with them under GDPR. So capturing consent then, as we've already said, if you're relying on consent as a legitimate reason for processing data, you need to step back and look at how you are getting that consent, and is it compatible with GDPR. If you have mailing lists that you've used pre-GDPR, you may not be able to continue using them if you haven't got the specific opt-in approval from individuals. And another point to be aware of here is at the point where you are asking somebody to opt in, that you make it clear that they can opt out at any time, and that there is no knock-on effect of opting out for that. And that might come in an employment situation as well, if you were asking employees to provide racial data or anything like that. They could opt out at any stage from that, and there'd be no knock-on effect. So the whole concept of deleting your mailing lists, if you don't get approval, it's harsh. We're going to have to do it here. We've been working hard to build up on our mailing list, but the reality is that yes, if people don't opt in before the 25th of May, we'll have to delete a huge amount of information.
But as Laura said there, I mean, I'm sure you've all noticed there's a massive amount of emails coming in looking for your specific consent to either continue receiving, mailing lists that you're already signed up to, or, could be from a company you were in touch with years ago. But again, that email that you're looking at will be looking for a particular consent or specific consent, and there should be a very seamless opt-out process built into it.
And then just on the governance side of things, under the governance, you'll want to develop your own compliance methods to ensure that, having put your initial steps in place, you can be compliant going forward. So that might include reviewing how you deal with data subject requests from your employees or customers. Do you have a process in place for breach reporting? Who's going to make that final call that we talked about earlier? Is it your consideration around your DPO? Is it necessary to have a DPO? And the final one that I have here is the update staff on data protection. This is a really key one, really. Have some sort of staff training, staff meeting, and mention it to staff, tell staff, inform them what's GDPR, how it's going to affect your business. That's going to be key, that the ICO will want to see as well.
Absolutely, because you are going to have those employees who are GDPR aware, but you're also going to have those who are going to go, what is GDPR?
Yeah, and you don't want a customer to ring in and say, are you GDPR compliant? And the person on the other end of the phone say, well, I've never heard of that. That's not going to look very favourable in your company.
Exactly. So finally, then we want to look at, the likes of your security. So you need to review whatever protocols or policies you might have currently in place and consider the integration of additional security measures that maybe have been specified under the GDPR. So again, the technical and organizational measures that we looked at earlier on, like the encryption, clean desk policy,
secure Wi-Fi, yeah.
Exactly, as opposed to having the open Wi-Fi. Yeah. And then your privacy by design and your privacy impact assessments. Again, do you need to create them, obviously? How are you going to implement them and review that process as well on a regular basis?
Like privacy by design and privacy by default, as I said, it's just about embedding privacy into your organization. So if it's a new project you're starting, up until now you might have considered marketing aspects, HR aspects, financial aspects. Now you'll have to have a heading of data protection aspect as well, and just show that you've considered it. We're doing really well on time today. We've got a full half hour for questions, but I just want to really touch quickly on how BrightPay is preparing. BrightPay data protection has always been a concern for us, but I suppose like all companies we've had to sit back and take stock of the data that we hold, how we obtained it and how we were processing it, and we have introduced a range of our own technical and organisational measures that are in line with the requirements of GDPR, and more details on these can be found on our website in the GDPR section, GDPR and BrightPay I think it is, including our updated privacy policies as well. Just, I suppose, to say one thing here, for payroll customers, BrightPay, we don't have access to your data files except where they've been submitted for support reasons. So overall, we don't have any control or authority over the safety of your data input. You alone are responsible for that. And where we do take files in for backup, we've got a range of security measures in place there. In terms of our Connect storage, obviously we are storing your data there. We use Microsoft Azure secure servers, and they're based in the EU, so there's no transferring of data out of the EU there. So that brings the webinar to a close. Before we get our Q&As up, we've talked about newsletters. If you'd like to continue receiving our newsletters, whether Bright Contracts or BrightPay, please do sign up on the questionnaire at the end of the webinar when you log out. Otherwise, you'll miss all our great webinars.
You don't want to miss out listening to us too.
So that brings us to a close. Thank you all very much for your attention. I suppose the final message should be to be aware. You are aware now. To get prepared, and really ignorance is no defence come the 25th of May. So I'll leave that there, and just bear with us now for a moment till we bring up our Q&As. I'll just say we've got half an hour for Q&As. We're going to try and take as many as we can. Apologies if we don't get to your question. We'll just get to what we can in the time permitted, and it's not that your question wasn't relevant or a good question, it's just the way they come in, I suppose.
So small self-employers who raise sales invoices required to put the name and address of the client on the invoices. Should they register with ICO and comply with GDPR? Well, yeah, I mean, you're dealing with personal data there, so the name and the address of the client is on the invoice, so yeah, it is personal.
In terms of registering with the ICO, again, the ICO have a fantastic resource on their website in relation to this. So if you go onto the ICO website at I think it's the top right or near enough the top right of the screen, there is a button that says register with the ICO. And you click on there, and then one of the options in there is, do I need to register? And there's a really, really quick questionnaire that you complete, and it'll guide you as to whether or not you register. So depending on your situation, so I would say the best thing to do there is go onto the ICO website, go through that little questionnaire. It takes 5 minutes, and then the actual registration process, should you need to register, is 20 minutes. It's really quick.
Absolutely, yeah. And the lawful processing aspect that we looked at there, I mean, you're in a contract with your client, so therefore your processing of that data is going to be lawful. You need to do it for the contract reasons.
I don't know. Sorry, just trying to understand the questions as well. Whether the data controller is required to obtain consent from employee if they are outsourcing payroll data outside the EU. Okay, so we already talked about the consent is not going to work from an employment point of view. You have to notify your employees. Certainly, we'll be relying on legitimate reasons. It's a legitimate reason you have to pay employees. I would have concerns that you're outsourcing outside of the EU to do your payroll. I think you'd need to be showing that you had looked at internal measures and why you felt the need to outsource it outside of the EU and have a consideration process there.
The legitimate reasons there are going to be your reasoning for it.
Yeah. How many years are employers required to retain documents? I think we've addressed that during the webinar, that you very much depend on. You'll be led by legislation. The HMRC have 3 years for some information and 6 years for other information.
Yeah.
Employment law is 3 years for organisation and working time and anything in relation to annual leave. So the legislation, you'll be guided by the legislation. GDPR doesn't give time frames. It just says no longer than is necessary.
Sorry, let's just jump down.
Sorry. Hold on. There was a question there. Can I, as a payroll bureau, Can I, as a payroll bureau, offer BrightPay Connect to my clients, and how? Yes, you can. It's becoming increasingly popular with our payroll bureaus to offer Connect, and it's a great solution for them. We offer bundle prices as well, so like a standard price for a Connect is $49, but we offer bundle pricing. Krista, we have we run smaller demos that show the benefits and how you would run it. So Krista, we might suggest that you go out and just sign up when you're logging out, sign up for a Bright Connect demo,
yeah.
and how you can best offer it to your clients. But certainly it's a great offering to have.
We supply self-employed contractors to our clients. Do they need to opt in even though they have wanted to work for us?
I don't fully understand that question.
So the subcontractors, well, if they're subcontractors, then you're going to have your DPA in place, if I'm reading that right. So they're self-employed. So
I'd be sure I'd have a confidentiality agreements in place with them. I'm not sure what they would opt into. If you want to maybe email us with more details around that question, we could maybe come back to that one.
Yeah.
I work from home in one of the rooms converted to an office. Do I require locked filing cabinets? Yeah, I would if you're working from home. It's not a piece of legislation. You don't require, it's not a must, but I think you need to be looking at taking all possible steps, all organisational steps, and certainly it would be prudent to consider having locked cabinets and doors.
As a small firm of 3 family employees, all directors, we now need to create an employee privacy policy. I mean,
well, you can just take the Bright Contracts one and it's all done for you, Julia, so it's really easy.
Yeah, regardless of them being family, you're still going to have to put in place, the policies in order to, be compliant under that stipulation with the GDPR, yeah.
Yeah, and next question, do we need to capture consent if all we post is invoices, contracts, letters? No, you're not posting anything that is in relation to advertising. You're giving information about your product or service. That's fine. You don't need consent. And the same will work actually just in relation to BrightPay. If you don't give us consent to receive our mailing list, we'll still always contact you in relation to a software upgrade or something that's necessary for the functioning of BrightPay or Bright Contracts.
Yeah, well, because you've kind of signed into a contract there because you've purchased it. So there is a legal obligation on us to provide you with the most up-to-date programming.
Okay. Somebody said they were late. Yeah, we'll be sending out a copy of the slides as well.
A question that does come up quite a bit in relation to the pay slips. The GDPR legislation has doesn't mention anywhere about emailing or not emailing or posting the pay slips out, so there's certainly no reason why you cannot continue to do this. Again, it's to be seen to be accountable and taking into account the organizational and technical measures to ensure the security. So that could be as simple as writing private and confidential on the envelope if you're posting it. using a secure envelope, or password protecting the email payslips if you have that as an option, things like that. So, there's no need to get tied up with, kind of things that much, but it does come up quite a lot in the questions.
There's a long one there, Cheryl, in relation to your theatre company and having approval from the parents, but you say you have photographs mainly of children from an audience show. You have an email confirmation from the organisation who have got the parental permission on our behalf. I think that should be fine if you... let us look into that one a little bit more, Cheryl. It's kind of a long question. We're trying to read it as we go here. We'll come back to you if you don't mind.
So somebody's just asked about the suppliers. So the suppliers will be the same. Once you're holding the information, you're obviously going to hold, names, addresses, NI numbers, maybe bank account details for your customers and your suppliers. That is still deemed as personal data. So it applies across the board.
Yeah. So I'd be contacting them to see that they're compliant.
Exactly.
As well.
Exactly. Yeah, absolutely.
So we've come at the webinar today from an employment perspective, but suppliers will be included.
Absolutely.
Okay. So one that's just popped in there. Can you advertise on your invoices? Not without consent. If you want to send out an invoice and then have a nice advert at the end of it, that's that you'll need consent from the employees to receive that advert.
The question does come up, if you have mailing lists in place already that you've been using for your existing customers or previous customers or suppliers, whatever it might be, come the 25th of May, you're not going to be able to use those anymore because you are going to need specific consent. Freely given, unambiguous consent has to be gotten from them, your customers or your clients, in order for you to continue sending them marketing or advertising information. So, whatever you're using now, you need to delete it by the 25th of May and either be in the process of setting a new one up, or, go and create that email and send it to your current listing looking for that specific consent. And once you have that, then you can use that as your proof of receiving the consent going forward.
Okay, just another one that's come in that we are doing payroll for one of our clients and we keep their employees' details on our payroll software, which is BrightPay. Fantastic. Do our clients need to register with the ICO and comply with the GDPR as well? I would imagine so. Well, every business, if your client is the data controller, you're their data processor, so the client has employee data, so certainly yes, they would need to comply with GDPR. I would imagine they would need to register with the ICO, but I think the best step for them would be to go in and do that little questionnaire online as well. The questionnaire, is there such a thing as a soft opt-in? I don't think so. I don't know what a soft opt-in would be. I haven't come across that term.
Okay, so I think this is going back to that self-employed, the subcontractors. So the tutors are self-employed and use us irregularly. So do the tutors need to opt in for us to keep sending them work? Well, you have a contract.
Contract for services there.
Yeah.
No, I don't think they would need to opt in.
No.
Your
your lawful processing there is going to be your contract or your agreement between them. So no, you wouldn't need consent for that.
No, it would just be, again, just important to have your proper contract in place with them.
Yeah, your engagement letter or your data protection.
No, your contract for service there, it's not like, rather than an employment contract, it's a contract with a contractor. That's what you need there. But they don't need to opt in. Are there templates on BrightPay for privacy policies for employees? Bright Contracts is our employment software, and that's where you'll find the privacy policies for employees.
There is a GDPR section in the online support documentation on all of our websites, so brightpay.co.uk and brightcontracts.co.uk, and you'll find a lot of our template documents in there as well. So the likes of the DPA is there, and the checklists that we spoke of earlier on as well. But the actual privacy policy, that's an embedment we're going to put into the actual contracts software itself.
I do annual accounts for sole traders. Am I still able to email them each year informing them that their self-assessment is due and asking if they want me to do it? Yeah, that'll be fine. What I'd say there is, again, it's just be important to put a DPA in place, even with those sole traders, Lorna. So again, use our template that we have online. Just go to them now and issue a DPA, and that'll allow you to just be sure you've got all your GDPR compliance in place, and then you're acting as much as a reminder to them, I would say, there than anything else.
Absolutely, yeah.
So I think that's actually not too many questions today. So I think we'll close it off there.
Absolutely. If you do come up, think of any other questions, certainly you can email us to privacy
at brightpay.co.uk.
Or else support@brightcontracts.co.uk as well. If you do have any questions, certainly email us and we'll try and help you out.
Yeah, perfect. Can we have a copy of the slideshow, please? Yes, you'll get that later on today. We'll send that out. Okay, so I think we'll close it off there. Thank you all very much for attending. I hope you found it somewhat informative. And the webinar is now over.
Absolutely. Good luck with your GDPR.